The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 939, coming to you on Monday the 3rd of June 2019. On this program, I will speak to you on the topic, Give Mediation a Try. Give mediation a try. But before getting into the topic, a few preliminary comments first, and as usual, my condolences go out to all families which have suffered recent bereavements. Secondly, I would like to remind all spiritual Baptists, particularly those of the Archdiocese, of our year-night service in memory of our former Patriarch Edmund John. He died on the 5th of June last year, 2018, and on Wednesday the 5th of June, that is Wednesday this week, we will be having a service at St. Elizabeth Cathedral at Belmont beginning at 7 o'clock in honor of his memory. I would just like to ask those churches which plan to attend, can you kindly get word to myself or to Sister Latoya John at Belmont, the number is in the phone book, or to any other member on the St. Elizabeth Church Committee to inform us how many members of your church are planning to come, because as of now we don't have any idea as to the likely size of the congregation. And being a year-night service, we have to make preparations. Naturally, we would like to know the numbers for which we have to prepare. So it would be very helpful to us if churches can, in the course of tomorrow morning particularly, because we'll be shopping for Wednesday morning. So in the course of Tuesday, you can give me a call at my office. If I'm not there, leave a message. You'll see the number in the phone book. Call Latoya John or Reverend Davis, Reverend Elsie Davis, or any person you know who belongs to St. Elizabeth, and say, look, my church will be coming, identify the church, and we'll be bringing so many persons. Okay? It'll be very helpful to us, because we don't want to run short and then we don't want to overspend. Okay? And speaking about our Archdiocese, let me remind all of the men who belong to the Spiritual Baptist Archdiocese of the Men's Conference, which will be held next week, Saturday, the 15th of June, at St. John's Christian Pilgrim Spiritual Baptist Church at Sion Hill, beginning at 9 in the morning. So all the men, and if you're a spiritual Baptist man, and even if you don't belong to the Archdiocese, you'll be welcome to attend first ever men's conference of the Spiritual Baptist faith. That is next week, Saturday, the 15th of June, beginning at 9 in the morning at St. John's Church at Sion Hill. And let me say hello to the members of St. Malachi. They're having a week of revival services. Of course, by the time this program is aired, they will all be in church. But I just want to let everybody know they are having a week of revival. They started last night, and they'll be going through every night for the rest of this week. Okay. Give mediation a try. You will recall, those of you who saw the program broadcast on the 13th of April, sorry, 13th of May, I spoke on the topic, the advantages of court-approved mediation. You recall that? The advantages of court-approved mediation. Just excuse me, please. That was program number 936. And on that program, I gave you some information about what mediation is all about. And I spoke very strongly in favor of mediation. The learned Chief Justice of the Eastern Caribbean Supreme Court is making a thrust in the jurisdiction of the Eastern Caribbean Supreme Court, and in particular in St. Vincent and the Grenadines, to try and interest the public in mediation. And as part of that thrust, she has set up committees, and we have a committee in St. Vincent and Grenadines, whose responsibility it will be to have various functions, town hall meetings and so on, to acquaint the people of this country as to what mediation is all about. This week, Thursday, the 6th of June, if you happen to be in Kingstown, you are invited to pass by that sort of mini square outside the post office, between the post office and where the Treasury used to be. You know, it's now used as a parking lot. Well, there would be a booth set up there by the Mediation Public Awareness Committee, and they will be giving out leaflets to the public, and they will be answering questions and informing the public as to what mediation is all about, and giving you the advantages of mediation. So that is this week, Thursday morning, between 11 in the morning and 1 p.m. So please pass by. If you happen to be working in Kingstown, and you take a lunch break anytime between 11 and 1, then you are invited to go to that booth and get some information and hear what has to be said about mediation, and I'm sure you will find it quite a pleasant experience, especially if you have a case in the High Court right now that has not yet been tried. Now, those of you who heard my program 936 on the advantages of court-appointed mediation would be hearing again on this program many of the points I made on that one. But I hope there would be many more viewers tonight who perhaps did not see the first program and who could benefit from what I have to say, even by way of repetition on this program. The beauty about mediation is that it is a process by which A trained person called a mediator, appointed by the court. Please excuse me. A trained person attempts to lead the parties to a case before the High Court towards an agreed settlement of the case. In mediation, nobody forces you to agree. Not your lawyer, not the mediator. But the mediator encourages the parties to come to an agreement and settle the case without the need to go before the judge for a trial of the case. Therefore, a mediated settlement is one in which the parties to the case arrive at a compromise where neither one party wins nor the other one loses. But it is what is called in popular parlance a win-win situation, in that both parties are encouraged to compromise. That is, you give up some of your rights, and the other party gives up some of his or her or their rights. And you walk out of the mediation, hopefully, having settled the matter. Unless you have been involved in a high court case, or unless you are close to somebody who was involved in a high court case, you wouldn't appreciate how stressful the process is. Especially if the case has been in court for years. And on the previous program when I spoke on this topic, I mentioned that it is not unusual to find cases that have been in the high court system in this country from 15 to 20 years. That is a lot of stress, because when you have a matter in court, no matter how tough you think you are, it gives you some amount of stress, some amount of uneasiness, some amount of unease, some amount of doubt, because every now and then, even though you think you have a strong case and you think you are bound to win, every now and then a little voice inside tells you, I might lose that case, you know. I know many litigants go to court feeling cocksure that they're going to win, and they end up losing. Now, when you lose a case in the High Court, it is usually a very expensive proposition. Because unless in the cases where you bring a case against the government and you lose, but the High Court says, okay, they wouldn't bother to charge you costs. When you sue a private person in the High Court and you lose, or if they sue you and you fight the case and you lose, you normally have to pay costs. That is, in addition to paying your own lawyer, you have to pay some fees for the other side's lawyer, the other person's lawyer. So you end up paying 2 lawyers. And normally It is expensive enough to pay one lawyer, let alone when you have to pay two. Now, I'm not saying you must go and settle the matter. If you really feel you have a strong case, it's impregnable, there's no way you could lose, you're not going to settle, well then that is your choice. But sometimes you think you have a strong case. Your lawyer genuinely believes you have a strong case and so advises you. Then, when the matter goes before the judge in a trial, things don't work out the way you had expected them to work out. Technicalities come forward which your lawyer had not anticipated, or anticipated the technicalities but didn't think they were going to have as serious an effect as it turned out they had. So there is no certainty that you will win your case in the High Court, no matter how strong it appears to be. You may have a good case at the outset, but when you yourself give evidence, frankly, you may mess up. You may say the wrong things, you may forget some parts of your evidence, confuse yourself, or allow the lawyer cross-examining you to confuse you. You make a bad impression on the judge. The judge thinks you are being dishonest and untruthful, which and while you may be trying your best to tell the truth, and you may be speaking the truth, but the judge may not believe you because you may give your evidence in a hesitant manner. You may keep looking down, and instead of looking at the lawyer to answer the question or looking at the judge, you keep looking down and you're mumbling your answers. When you behave like that, mainly because you're frightened to death, because being on the witness stand giving evidence in court is a stressful experience. Even lawyers who have gone on the stand to give evidence in a case find the whole procedure unnerving. You get nervous. Or let us say you have given your evidence in a straightforward manner and you appear to be credible, and the judge is impressed with your evidence. Along comes one of your witnesses and messes up. Gives evidence which make you lose your case. Says things which they had never told your lawyer before when they were being interviewed for a witness statement to be taken. Is induced by skillful cross-examination by the other lawyer to say the wrong things and mix up themselves. And you are there sitting, because you can't interrupt when your witness is giving evidence, and you're hearing some strange things coming from your own witness. And you're asking yourself how he could be so stupid. Why he answering them kind of questions in that kind of way? Man, he messed me, he let me down, man. Those things happen because the witness may be frightened to death on the witness stand and may mess up your case and make you lose. So when you go to court and you are facing a trial, there's no guarantee you will win the case, no matter how strong you think the case is. No guarantee. And if there is room to settle the matter, it is better to try and settle it by mediation. Now, a mediation is not a trial. The mediator is trained in techniques of persuasion and how to get things out of people. The mediator listens to both sides, together and individually, in private. And the mediator may make suggestions to both parties. The mediator is not taking any side. He is not for one or against the other one. He is simply trying to bring the two warring parties together, to compromise. Now, when you go into mediation, you have to be prepared to give up some of what you regard as your rights. That is what compromise means, giving up something to get something. Both parties give up a little bit to arrive at a settlement. If the mediation fails, if in spite of the best efforts of the mediator, no agreement emerges from the session, the mediator might suggest, look, let us try and meet again. Okay? One party may say, look, it's a waste of time. I'm never going to agree. So there could not be a second meeting, but the parties may say, okay, give it another try. You give it another try, and yet nothing positive emerges. You're still deadlocked. The matter goes back before the judge, and the judge is told the parties have failed to agree. Now, the judge cannot be told what happened in the mediation session. All the judge must be told is whether there was agreement or whether there was not an agreement. The judge cannot hear the details of who said this and who was willing to do this and so on. And the mediator cannot disclose what happened during the mediation session. The mediator is sworn to secrecy. Nor can the mediator be called before the judge to give evidence as to what happened in the mediation room. No way. So, the mediator is trying to make peace between two sides, or if there are more than two sides in a case, between how many sides there are. But believe you me, from my own experience of gone with cases to mediation, when the parties decide to settle a matter before the mediator, it is the best possible outcome, because the result of the case has been up to them. You don't run the risk of a witness saying the wrong things and throwing away your case by speaking out of turn, by not remembering vital things when the time comes to say them. You settle the matter. You save time, you save stress, and you save money. Believe me. So that I have called this program Give Mediation a Try, in appeal to those persons who have a matter before the High Court or who may have a matter in the future before the High Court heading for a trial. Successful mediations save the judges a lot of time, effort, and energy, and we only have 2 civil judges here at any one time. A far cry from the days when we only had 1. Both judges at the moment happen to be female. Excellent judges. And the rules of court encourage lawyers to suggest mediation to their clients when they have a contested matter. Final point I want to make, however, not every type of case is suitable for mediation. You cannot have mediation in a divorce case, at least not when it comes to whether there are grounds for divorce or not. You can have mediation after the main part of the divorce case is finished, where the judge pronounced that this marriage has broken down irretrievably. You can have mediation on the settlement of property matters and custody matters and so on, but not on the fundamental issue as to whether the marriage has broken down. So there are some types of cases which are not suitable for mediation, but the bulk of the case, the vast majority of cases, are capable of being settled if the parties demonstrated some goodwill, peace on earth, and goodwill to all men. And if the parties were not bloody-minded, as the English would say, if the parties behaved like reasonable people, so that you can go back after mediation, back before the judge, and be happy that you have arrived at a compromise solution before the mediator, and you would like the judge to make that an order of court. And once there's a mediation agreement, and the judge makes it an order of court, then it's enforceable, as if the judge had tried the case and arrived at the decision and had made the order by herself. So that mediation agreements have the full force of judgments of the High Court. The judge has to be satisfied by a certificate from the mediator that this matter has been settled. The terms of the settlement are written down. The judge would normally confirm with both sides that they understand the settlement and they agree to abide by it. And once they say yes, bam, that is the end of the litigation. So I say yet again, give mediation a try if you have a matter in the High Court that has not yet gone to trial. And the matter could go to mediation anytime before the trial. Not too late. Okay? So, blessed are the peacemakers. That is all from this program of the Law and You. Let me remind persons in the Spiritual Baptist community that we are having the year night service on Wednesday night this week at 7 o'clock at St. Elizabeth, Belmont, in honor of the memory of Patriarch Edmund John. And we have our men's conference coming up on Saturday the 15th of this month at St. John's, Sion Hill. All right? Look forward to being a further service to you next week, Monday, Divi, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.